what is the right to information? In short, it means you can take photocopies of records, you can actually get information within some reasonable limits, and you can also take samples, samples of roads, samples of food grains, samples of medicine. All these are available. Usually we have not used it very much, but this can be very useful if you want to identify where you suspect, let's say roads are bad. If you know, if I test A, B and C, I can spot on and conclude that the road is bad, the construction was bad, the maintenance was bad. I think it'd be very useful. If you believe food grain quality is poor, you can take a sample from the FPS, get it tested, get it checked, and so on. The most section of right to information which is hardly talked about is section 3. It's the most succinct, and in very brief it says, subject to the provisions of this act, all citizens shall have the right to information. Beautifully worded. We rarely pay attention to it. And remember, when you interpret laws, the higher the section number, the greater its importance. Therefore, this is the sole thing which I think all PIOs, all citizens need to look at. Since this is the case, what is the reason on which information which exists can be denied to a citizen is only under the provisions of section 8(1) of the RTI Act. And section 9 of course says if there is a copyright of somebody then it be denied, but that's a rare case. Generally it is the 10 provisions of section 8(1) of the RTI Act, because this has said very clearly. I have seen a number of PIOs who say this is not in the interest of the nation. It is not for an individual PIO to decide, it is not for in the jurisdiction of a commissioner also. There are a lot of orders of various commissioners across the country which have said this. This is not in public interest. You are nobody to judge that. There is a parliament. If we want to live by the rule of law, we have to respect the parliamentary provisions as laid down in this act. And this act says, subject to the provisions of this act, all citizens shall have the right to information. That has been given. In fact, there is another subsection in which it is said that there is no need to give any purpose. The only reason, the only time, I mean the exception to this laid down in the act itself, not in those many words but effectively, is if you are claiming public interest, a large public interest, because under section 8(1) things that I may not be given, but if you show a large public interest, when you want to show a large public interest, you will have to explain how that large public interest comes in. Short of that, you do not need to establish any locus standi in this act. Section 4, Mr. Mundra talked about it, and I think this is the most important part of the Right to Information Act. Very limited attention has been paid to by public authorities, government in particular, and information commissions. I plead guilty to this. I think information commissions have also not given enough attention to this. Some activists have been focusing on this, but in general, citizenry has not been very enthusiastic about it, but it's very important. What section 4 says is that everything should be out suo moto. And let me give you a simple example of what this can mean. The US Securities Board, if any individual, private individual goes and has a talk with any person in the government department in the US Securities Board, next day the minutes of that meeting are on the website. This is a requirement of the United States Security Board. Therefore, just think, because people will ask, people want to know when a private person goes and talks, let's say to the Reserve Bank governor, or an industry person or a business person or another banker goes and talks. They want to know what the whole issue is. And if you believe, I'm saying if we believe, or somebody comes and meets an information commissioner, people want to know what did I talk when I'm talking in my office. When I talk in my house to my wife, that's my personal issue. But when I'm talking in an office to anyone who comes and meets me, it's an official business. And a citizen has a right to know. If I believe I'm discussing something that I cannot share, then I believe I have no reason to really discuss those things, unless it's a matter of national security and so on. And let me take you back to Justice, what's the name? This is a Radnarayan case, Justice Matthew. In the Radnarayan case, he's made a brilliant statement which says, unless information concerns the security of the state, we should be very wary when people claim we do not want to give information. Therefore, I would submit that section 4 is a heart to this. Whatever we do on computers in various offices, why don't we just put it up, barring a few things which we may consciously decide cannot be put up. If we make our section 4 powerful, then the need for right, I'm not saying it will go away. Believe me, in spite of that, RTI applications will grow. I do not believe that when you have a lot of section 4 people, because an individual will still have that need to get information of the kind that that person wants. To give the US example, US in a way compared to India is far better in the transparency index. And yet, FOI applications, freedom of information is what we call RTI, have been growing in leaps and bounds, absolute leaps and bounds. They are far more than we can even imagine in India. And the Supreme Court judgment that you referred to, sir, I would submit with great humility, is a very retrograde statement. It unfortunately does not understand what a true democracy is really all about. And with deep pain I am saying this, before the RTI Act came, the Supreme Court time and again has talked of transparency and right to information being the fundamental right of citizens. Unfortunately, after the Right to Information Act was promulgated, the courts have been the biggest laggards in giving information. And this is true culturally. Most of us, I've individually also I realize, everybody feels giving information is good for everyone else, not for me. I mean, I sometimes joke that men probably think it's nice if everybody else's girlfriends wore transparent clothes, but their own girlfriend should be in burqas. So this is the kind of attitude we are displaying, is my submission. Section 5 talks of deemed PIO. The critical point I want to bring across, particularly to PIOs, when you seek the assistance of another officer, that person becomes a deemed PIO. However, if you look at the law strictly, there is no provision for a deemed PIO to then seek further information and transfer the liability. Then it's his administrative responsibility, really speaking, to get the information and give it. And this is especially relevant in terms of penalties. When the issue of penalty comes in, if the PIO has sought somebody else's assistance, that person becomes a deemed PIO. I'm just giving you a small thing. When I was in Mumbai as an activist, when the RTI Act came, I realized that the High Court of Delhi, the High Court of Bombay rather, is a separate public authority with the right to make its own rules. They had not made any rules. So I asked under RTI about some query and they said it's available on the website. And the answer was, I have been instructed to inform you by the Chief Justice of the High Court that the information is available on the website. I went to the website, the information was not available. Checked with the person who had sent this letter and said, look, the information is not available. So she said, yes, sir. So I said, then you've given me false information. She said, sir, the Chief Justice instructed me. I said, in which case, your Chief Justice becomes a deemed PIO. 6 again talks of how to deal with an application, etc., which is, I think most of you are probably reasonably familiar with it, and disposal of a request. The only thing is disposal of a request is that within 30 days is not provided, it's a deemed refusal without reasons. And the Act requires that you give reasons. And if you look at the penalty clauses in section 21, if information is denied without reasonable cause, this is where a penalty has to be imposed by the commissioner. There are other words like malified, etc., but if you read it very carefully, the other words are irrelevant. If there is no reasonable cause, if there is a reasonable cause, of course there may be a delay, but if there is no reasonable cause, penalty has to be imposed. Therefore, PIOs, I would tell them that within 30 days, they must make the attempt to give the information, and the 30-day clock works like this. Day on which the information, the RT application is received by the PIO is day 1, not the day on which the RT applicant sends the application. From there, supposing the PIO sends an answer saying you need to pay so much as additional fees at 2 rupees per page, for 20 pages 40 rupees. The moment that letter is sent, the clock stops. Supposing it is 10 days arbitrarily. From there to the time the payment is made, it's 0 days. The moment the payment is made, the clock starts again. So then it'll be 11 day, and then the total time is 30 days, the first and the second segment. Where information has to be, this is very common problem with most PIOs. They say, I am denying information under section 8.1 so and so. You have to give reasons, at least at some level. And I tell PIOs that if they give reasons, they would themselves sometimes realize that the exemption does not apply. When you give no reasons, you kind of feel, ha, aisa hoga, and you say section 8.1J, section 8.1E. The moment you try and give at least reasons in brief, you will yourself realize at the time of adjudication before me also, the simple reason I ask, there are some where it's obvious, but otherwise I often ask an PIO, please explain how does this exemption apply. And I have found half the times the PIO has no explanation. He just says, sir, haan, aisa hata hai, I was been told, or there's another commission decision and so on. But please reason, let's understand. And I repeat, when you are denying a citizen a fundamental right, your reasons have to be valid. They cannot be, shayad aisa ho jayega. They have to be concrete reasons defined under section 8.1 of the RTI. Section 8.1, this I suggest applicants and PIOs must go through as many times as you can and read the wording fairly accurately. I will take the liberty of reading this with you. Information disclosure of which would, notwithstanding anything contained in this act, there shall be no obligation to give any citizen. Information disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific or economic interests of the state, relation with foreign state or lead to incitement of an offence. And I would certainly concede that Reserve Bank of India, in some of the information that you talked of, may fall here. And I would say 90% or 99%, if the Reserve Bank of India said that this is likely to hurt the economic interests of the state, the nation, most commissioners, including me, would probably say, okay, unless it's completely unreasonable. I mean, like, I'm not talking of the Reserve Bank, but I remember in my earlier days as a RTI activist, I had filed for an agreement of Dow Chemicals with one of the government departments. And they had used this clause. Now, I think that that's stretching it too far. Governments deal with a private company cannot be said to affect the economic interests of the state, but in the case of Reserve Bank, I would certainly concede that. B, information which has been expressly forbidden to be published by any court of law or tribunal or the disclosure of which may constitute contempt of court. In very simple terms, it means there has to be an express ban. Without sub judice cannot be covered by 8.1b. Parliament did not intend to cover sub judice. Parliament knows the word sub judice. So if they wanted to cover sub judice, they would have said this. Parliament has only said which has been expressly forbidden to be published by any court of law or tribunal. Or the disclosure, it's actually saying the same thing. Disclosure will become a contempt provided it's been expressly banned. Of course, one case is where something is held in camera, you cannot give the information because the ban is implicit when a court says that this is in camera. But I repeat, and this is a mistake made repeatedly by PIOs across the nation, they say, sir, the matter is sub judice, therefore we will not give information, which is not a basis at all. C, information, the disclosure of which would cause a breach of privilege of parliament to the state legislature. This is interesting. So, okay, obviously, let's say you ask for budget papers before the budget is presented. They can't be given because it will be breach of parliamentary privilege. However, there have been cases, numerous cases in our country, and all of you are aware of this. Numerous inquiry commissions are set up at public money, and because the results are not favorable or the results are things which would be embarrassing, they never publicize the inquiry commission report. In a bench judgment, we had this issue, and the position we took was the Commission of Inquiries Act says that the report has to be placed in Parliament within 6 months. So the position we took was, we said within 6 months you can claim exemption under this. But after 6 months are over, 1 year, 1.5 years later, you may decide not to put it in Parliament. then it cannot be considered breach of parliamentary privilege or legislative privilege. The information would have to be shared. So all commissions of inquiries reports, which so far have been going under the mats, will have to keep coming out. You can keep asking, and I think it's a very important way to do this, to keep our legislature and parliament in check. D, information including commercial confidence, trade secrets or intellectual property. Information including commercial confidence, trade secrets or intellectual property, the disclosure of which would harm the competitive position of a third party unless the competent authority is satisfied. The public interest clause is also coming later on. Now this must be commercial confidence, trade secrets or intellectual property. Basically, I often have felt that the word intellectual property has been perhaps not really required, because what is intellectual property? Let's say a patent. A patent by very definition has to disclose publicly the method of doing something in a manner which anyone with knowledge of that trade can replicate. It has to be there in your patent application. If it's not there, you can't get a patent. However, the other thing is commercial confidence again. What is commercial confidence? One must at least apply one's mind to figure out, is this a matter of commercial confidence? I believe one of the essentials of that is that it must be information which would not normally be available in public domain. You cannot, because I have seen people often claiming everything is commercial confidence, and it must hurt the competitive interest. For organizations that are in a competitive business, at least you can apply that. But there are organizations which are not in any competitive business at all. How can you apply this to such organizations? Banks, I concede, could fall here, but it cannot be applied to other. Police cannot say my competitive interest is going to be affected because they have no competition at all. But people have used this, all kinds of departments use it. Information available to a person in his fiduciary relationship unless the competent authority is satisfied that, okay, now this is beautiful. The word fiduciary, to my understanding, was not very well known in government departments before the RTI Act came. But after the RTI Act came, it has become a very popular word. Everybody says everything is fiduciary. My submission is, and I have defined it in a order, lots of orders in fact. Let me explain what I believe is fiduciary. It's a relationship where primarily the issue is trust. You will not undertake, you will not give information to such a person unless you trust that person. B, you must have a choice about giving the information. If you have no choice, I would submit it's not a fiduciary relationship. What we call the traditional fiduciary relationships, a law and client relationship, banker-customer relationship, in a confession, a father and a person who goes and makes the confession. These are traditional fiduciary relationships. A doctor-patient relationship, this is a fiduciary relationship. In these relationships, the person who gives the information has a choice whom to go to. You can choose to go to a particular lawyer or a particular banker or a particular investment advisor or a chartered accountant or a doctor. You have a choice. When you have no choice, I do not believe it's fiduciary. People say, but sir, there has to be trust. Trust is in all relationships. I am here with you and you are here with me in this hall because we trust that one of us is not going to pull out a gun and start shooting. So this does not become a fiduciary relationship. Trust will be there in most relationships. My own submission is employer-employee relationships are not fiduciary. No employee gives information to an employer based on trusting. He gives it because it's a requirement. If I apply for a job, quite often this has been raised, people have applied for jobs with fake certificates. Citizens ask and say, we want a copy of that certificate, we want a copy of his academic qualifications. And fiduciary, as I said, has become very popular. People don't understand the term, but RTI Act has made this term extremely popular everywhere. Everything becomes fiduciary. People have said names of people who applied for a job, fiduciary. I mean, this I think is stretching it to an extreme. Fiduciary relationship has to be defined in a restricted form. F, information received in confidence from foreign government. Now, amongst the exemptions, remember, one place where this word confidence, I don't like the word frankly, as a pro-transparency person, but it's there, in section 8.1f. This is the only place in the 8.1 that you find this confidence or confidentiality word. PIOs use it various places saying confidential hai, confidential hai, you can't refuse, that's not. Effectively the word, the section 81F means that any information given by any foreign government, if the government claims this is given in confidence, one will have to respect that. Effectively, I mean that's the way the law has been laid down by Parliament, we'll have to respect that. It's up to government to decide whether it's given in confidence or not. Effectively, government can refuse to give any information given by a foreign government to it by saying it was given in confidence and we really cannot do very much about it. Information, the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence for law enforcement or security purposes. Slightly misused at times. I'll give you one example. In fact, somebody had sought some report made about him by his boss. And this was one of the good ministries in this country. They said, sir, 81G, we will not give this information. So I asked the PIO, I said, do you really believe your employee, you're talking about your employee, mind you, not somebody on the street. Do you really believe your employee is capable of endangering somebody's physical safety? Yes, sir. I said, please think very carefully. He said, yes, sir. So I started dictating my order. I dictate my orders immediately and the orders are given as soon as the hearing is over. So I started dictating my order. I said, this organization believes its employees are capable of endangering the physical safety of others. This guy was horrified. He said, sir, don't write like this. But I said, this is what you are telling me. I'm not saying that. I didn't say your employees are gundas and badmash. You are saying your employees are gundas and badmash, so I'm writing it. He said, no, no, sir, I don't want to claim this exemption. The information I had to provide. So please think carefully. Don't use this because, especially if you come up with someone like me, I will say, fair, you want to do this, I will put it down in writing. And that would become very embarrassing. So before you use your exemptions, please think carefully. And let's remember, denial of information is denial of a citizen's fundamental right. So therefore, let's treat that with some respect. I'm not saying you must give all information, where definitely it's exempt, do deny. But do it with some care is my submission to all of you. Information which would impede the process of investigation or apprehension or prosecution of offenders. This exemption, I would say lots of commissioners have completely misinterpreted. PIOs of course do. CBI and various such organizations have used this time and again. They interpret it like this: when an investigation is going on, no information will be given. When a prosecution is going on, no information will be given. Let's read the law. The lawmaker said, information which would impede the process of investigation or apprehension or prosecution of offenders. If Parliament wanted to say that whenever an investigation is going on or a prosecution is going on, information should not be given, they could have said that. They would not have used the word impede. One cannot imagine that a word used there is superfluous. So therefore, some element is to be brought to show that giving this information would impede the process of investigation. I have dealt with a number of cases of CBI and others, and they are unable to show anything of that nature. They just say, sir, investigation chal raha hai, prosecution chal raha hai. So what? Unless you can show that it will be impeded, this information, I would submit, has to be provided. Cabinet papers, including records of deliberations of the councils of ministers, secretaries and other officers, provided that the decisions of councils of ministers and reasons thereof and the material on the basis of which the decisions were taken shall be made public after the decision has been taken and the matter is complete or over. This again, a lot of people claim anything that goes before the cabinet is exempt, which is not the case. The actual decision of the cabinet is exempt, but the other material would have to be reviewed. And this has been specially brought out in the Bommai judgment by the Supreme Court. It was, I think, a 9-member or 11-member Supreme Court judgment, in which this principle has been earlier, before the RTI Act came also, this has been established. Somebody had sought in Delhi, they said there were actually two parts to the query. This was related to the President's office. One part was they said they wanted the list of assets of the President. And the second was they wanted the advice given by the Prime Minister to the President to declare emergency and the material based on which this was given. As for the first part, the assets, I realized that, okay, and the PIO had said the assets are not available. So I said, if assets are not available, PIO cannot give it. However, I put in a line and a request that had some impact. I said, in the current scenario, Supreme Court judges are declaring assets, Prime Minister and other ministers are declaring assets, information commissioners have declared assets. It may be very nice if the President considers this. And left at that, I said, I have no business nor jurisdiction to order this. Incidentally, as a response to this, within 4 weeks, the President did declare the assets and put them on the website. Second part, on the emergency thing, I took care of, I referred to the Bombay judgment and said that the actual advice need not be given, but the material on which this advice was given would have to be revealed. This incidentally has been stayed by the High Court in Delhi, but stays are simple. Anybody can go to a court, and I really have no solution unless we get courts which give decisions fast. I have no clue how we can stop this train. Okay.